All right, we're back on the record in the 53rd Circuit Court.
All right, we're diving straight into a real courtroom session. And trust me, what seems routine at first, it rarely stays that way. Pay attention, because in cases like this, the smallest decisions can snowball into serious consequences.
And we're calling People v. Paulino, file 21-6122FH. We have Ms. Paulino appearing by Zoom audio only with some video problems. We have our attorney, Mr. Gilbert, in the courtroom, as is the prosecuting attorney, Ms. Goodrich, and we're providing public access online. The time and date set for a docket call. Mr. Gilbert, do you know how we'll proceed?
Your Honor, when I spoke with Ms. Paulino, we were going to ask the court to put this on the trial docket. However, I have spoken with the prosecutor again since that conversation, and she's come up with some alternatives of a possible resolution. I know I believe she wants me to talk with the agency involved in this case directly and see if I can work something out, and I'm more than happy to do that. So we don't have a resolution at this point.
Okay.
But I think there's one on the horizon.
Notice what just happened here. This is classic pre-trial negotiation territory. No resolution yet, but both sides are hinting at a deal. Question for you: would you push for trial or take a possible agreement that's still unclear? This is where strategy starts to outweigh emotion.
Okay, any objection to a continuance, Ms. Goodrich?
No objection.
A continuance might sound harmless, but legally, it's a delay, and delays can work for or against you. More time can mean better preparation, or more time for problems to pile up.
We can continue this to August 10th at 2 p.m., but we'll schedule that to be held in person. Okay, Ms. Paulino, did you hear that?
I heard that the last part I didn't hear.
It'll be here in the courtroom,
Okay.
August 10th, 2 p.m., here in the courtroom in person.
Okay, so then the courts are going to open?
I can't hear you.
The courts will be open, so we go right to the court?
Yep.
Okay. Okay,
Okay, see you then.
okay. Am I done now?
Yep, you're done. Have a
All
good day.
Bye-bye. You too, bye-bye.
Let's call People v. Caleb Stewart, two file numbers 21-6067 and 6085FH. It's the time and date set for sentencing. And bless you. And Mr. Stewart has been participating in our recovery court program and is scheduled for sentencing today into the recovery court formally. And sadly, though, he's not here today.
And here's where things take a turn. This isn't just any hearing. This is sentencing tied to a recovery program. Missing this? That's not a small mistake. That's potentially throwing away a second chance.
Mr. Gilbert, do you have any information about that?
Your Honor, we've been trying to contact him. I saw him as recently as last week in our recovery court, and so I'm not too sure why he's not here today. I did contact one of his contact numbers. They said he was having an issue with his phone, that it broke, and that he had to get insurance for it. She was going to try to relay a message to him by instant messenger. However, he's not here. However, I don't understand any reason other than an oversight that he wouldn't be here, because this is what he's wanted for quite some time. So I'm slightly confused.
Oh, the attorney's confusion says it all. When even your own lawyer doesn't know why you're absent, that's a red flag. In court, showing up isn't optional. It's everything.
All right, well, we are scheduled for a recovery court weekly review hearing tomorrow morning. Ms. Goodrich, any objection to us seeing if he appears tomorrow morning and we can sentence him at the end of that hearing? Or?
No objection.
All right, so I'm going to give him until tomorrow morning. If he's a no-show tomorrow morning, we'll have to warn.
Understandable.
All right, and then there's a Kiana. Let me see who that is. Kiana's oh, this is Mr. McQuaid. All right.
Can you hear me, Your Honor?
Yes. All right. Are you Mr. McQuaid?
Yes, Your Honor.
All right. So we're calling the case of People versus Cameron McQuaid, file 18-5564FH. Mr. McQuaid is appearing by Zoom video. And this is the probation agent's motion to extend probation. The request is that the probation would be extended by a year to expire instead of on August 21st, 2021, to extend it to August 21st, 2022, because Mr. McQuaid has not addressed financial.
Wine. Let's break this down. Probation isn't just stay out of trouble. It's a checklist: fines, treatment, education. Miss those? The court sees non-compliance, and that opens the door to harsher penalties.
Obligations, completed substance abuse treatment program, GED requirements, and then he did not address them previously because he had been a probation absconder and then had served a jail sentence, and now he's released from jail and back out on probation. So, Mr. Gilbert, are you here on that case?
Your Honor, I don't know necessarily. I did try to get a hold of Mr. McQuaid so I can discuss it with him. However, none of the numbers that I had worked any longer. So I'm here if the court wants me to.
Okay, well, it's unclear from the probation or from the criminal justice reforms whether indigent defense would be provided at a motion to extend the probation. We had taken the position that we certainly would if people want that. But Mr. McQuaid, let me just ask you here. So we had some issues on probation, and then you had a violation and had to sit some time. Now you're back on probation. Looks like there's still some things you need to do. Do you have any objection to us extending your probation 1 year to August 2022 to give you time to complete those things and possibly discharge successfully?
Your Honor, I was going to ask if there's any way I could possibly get off probation and still address my court fines and stuff like that.
Well, it's not just fines, it's substance abuse treatment, GED. Have you done those things yet?
I actually did 3 out of the 4 GED tests, Your Honor. I'm currently trying to get an appointment set up for the math GED.
All right, have you successfully completed a course of substance abuse treatment?
I did go to Harbor Hall once, Your Honor. I believe I was supposed to do another one and I did not make it in there.
That question right there. It's almost rhetorical. The judge already knows the answer, and now it's about seeing if the defendant realizes it too.
All right, does that sound to you like you're done with probation then?
No, Your Honor.
All right. I'm going to extend your probation to August 21st of 2022, because the other option, Mr. McQuaid, if we don't extend your probation, you haven't successfully complied.
This is a critical legal moment. The judge lays out the real options: more time or more jail. Not exactly a tough choice, but it shows how the system balances punishment with opportunity.
So we'd have a violation hearing and decide whether to give you more jail and how much. So it's not like the options are cut you loose or keep you on. The questions are, do we violate you or do we give you more time? So understanding those options, do you have any problem if I give you more time?
I'd just like to continue probation then, Your Honor.
Okay, I think that's a good decision, Mr. McQuaid. So I've signed the order extending your probation to August 21st, 2022. So be in touch with your supervising agent and make sure you get those things done. I don't want to have to give you more jail in this case. I really want you to complete those things so we can discharge you successful, okay?
Yes, Your Honor.
Okay, good luck.
Thank you.
Bring in Mr. Stewart. I honestly have no idea under the criminal justice reforms whether we did that right. I think we did it in a way that makes sense to me.
Hey, I'm in court right now, and
Oh, no. Mr. Stribbett, can you hear me?
Can't get anybody to answer the phone.
Mr. Stewart, can you hear
To
us?
see if I can find right now. I got one. I got a couple of them. They're
Hold
probably
up. Hold up. Hold on. All right. Can you hear me, Mr. Stribbick?
Not really. Okay, yeah.
All right. So we're back on the record. We're recalling the cases of people versus
New case, new problems, and this one's about proof. Because in court, it's not what you say you did, it's what you can prove.
Joseph Stribbick. It's filed 21-6081 and 6116FH. We've given Mr. Gilbert time to discuss the matter with Mr. Stribbick. And we're here on a docket call and bond violation hearing for contempt. And Mr. Stribbick, I know it was that Mr. Gilbert advised you here in the court, we have no proof that you have taken a single drug test.
I understand that. I have one of my receipts right here. And I've taken over 5 tests there for sure. I asked them though that they said they keep all their records and that they will fax them to the courts if I need them. But the number I got for the place, I text it and I call it and they won't pick up. Usually not till after 5.
Your Honor, Mr. Stribbick has advised me, I believe he's going to the advanced.
We just, hold on. Turn your camera back on, Mr. Stribbick. Go ahead, he's there.
Sure. Your Honor, Mr. Stribbick advised me that he had been testing at advanced drug testing. I informed him that he needs to get a hold of them and get receipts faxed to the court. So that doesn't seem to be happening.
And here comes the issue, missing documentation. In legal terms, if it's not on record, it might as well not exist.
Mr. Stribbick, can you hear me? We seem to have lost him. I'm going to add this to next Tuesday's docket at 3:40 in person. We have a bond violation hearing at the same time. See if this is him so I can tell him that. I'll give him a chance to get those receipts. It's not the court's job to track down those receipts.
I understand. And Mr. Stribbick has been advised of that.
Okay, Mr. Stribbick, can you hear me?
Yeah.
All right, here's what we're gonna do. It's not my job to get the receipts, it's your job. So I'm gonna continue this hearing 1 week. So July 13th.
Could I have
Next
them
Tuesday.
fax them to you guys?
Hang on, just listen for a second. Next Tuesday, July 13th at 3:40 in the afternoon, you're gonna be in my courtroom personally, Mr. Stribbick.
Okay.
And you can get
July
any of those
13th?
receipts to July 13th, 3:40 in the afternoon. And you can provide any of those receipts to your attorney before then. If he wants you to send them to the court, go ahead and do that, but I would check with Mr. Gilbert first.
I'll have them for sure.
And we'll get this sorted out next Tuesday. But next Tuesday, Mr. Stribbick, I just want you to know, if I'm not convinced that you are testing as required, I will be revoking your bond that day.
There it is, the turning point. Bond revocation means immediate custody. One missing piece of proof could mean walking out or being taken away in cuffs.
Well, I do mine online, so I have history of how I do it. I go online on the My Call-In, and I do it like that. So I have record of every morning when I do it on the phone.
Okay.
I don't
all right,
call the
well,
number. I do it all online.
Okay, I'm just letting you know, we've got to make sure that you're testing as required, okay? So get that information to Mr. Gilbert.
I'll get everything I can together.
Yes, yeah, we got to have the test results, Mr. Strivick, not just that you were
Want me
calling
to
in. We don't
get
have any
my-
of the test results.
Yeah, I mean, I don't know, it's out of my hands. I was just gonna go to him and tell him I need them, because I mean, I just pay him the $20 and he gives me a receipt. I got them.
Well, let me tell you, if the agency that you're going to is not getting receipts to the court, you might want to think about going to somewhere else to get tests. There are 3 agencies in town. If one of them is not helping you out.
Yeah, you're right.
you know, I would switch agencies before I go to jail for somebody.
Yeah, I agree. Yeah,
All
I
right.
will. I'll start going
But
to the one in
that's-
town.
In that line right there sums up the entire system. The court sets the rules, but it's on you to prove you followed them. So here's the big takeaway: how much responsibility should fall on the defendant and how much on the system supporting them.
That's your job to sort out, not mine. So you've got to prove to us that you're testing as required. So we'll see you next Tuesday in the
I have
court.
been calling it and I have been testing. I just got to get the paperwork from them guys. He says they have it, and if I ever need it, I'll get it.
Okay. All right. We'll see you next Tuesday at 3:40 in the courtroom, Mr. Sturdy.
Okay, thank you.
Okay. All right. And I believe that concludes our docket this afternoon. We'll put over Mr. Stewart until tomorrow morning at the conclusion of recovery court.
Thank you, Your Honor.
All right.
Um,
And, what's this?